Since Judge Lyman might be responding to my sanction request here soon, let's go ahead and re-go over it. So the reason you're not able to see it on the docket, you can see here it skips my number 733 because it's currently in judicial review. So basically, Judge Lyman, he's reading it over, thinking about how he's going to respond, and then writing up his response. So at any time between now and the end of November, we should be getting a response. I apologize in advance. My phone did just die on me, so bear with me through this. So just to clarify, this is my formal motion for sanctions after Blake tried to subpoena me for my data. So I'm going to go through the backstory within this motion, so bear with me.
I'm just trying to help you move on.
Oh, you are a petty man. You are a petty.
July 10th, a day I'll never forget. Thanks, Blake. That's the day that Google notified me that they were issued a subpoena for my data from my YouTube from Blake Lively. It was interesting getting this notification because at the time I only had one subscriber on YouTube. I'm not joking. And no, it was not me following myself. No, it was not my mom. I saw that was a theory floating around. Hate to break it to you guys, she is not with us. So there was also the issue of my TikTok had 10,000 followers, but she never went after my TikTok. She went after my YouTube with one. As any rational person would do, I reached out immediately and responded, can I get a copy of the subpoena? And I also reached out to Ezra, Blake's whole legal team, asking for a copy as well. Then the very next morning, as soon as Blake's legal office opened, I called and left a voicemail asking for a copy of the subpoena and just asking to confirm that it was legitimate. Because at this time, I was still unsure that this was actually really happening. I think I was just stunned, honestly. Like, there's no way she's going after little old me, like Blake Lively. Me? What? It wasn't until July 14th that I actually got a copy of the subpoena from them, Google at 12:56 and Blake's team at 3:53. So towards the end of the day, they were finally like, here you go. Here's your subpoena. Here's your copy. And this is, like you said, everything that they requested. So not just a little thing here or there. The fact that I had already made multiple videos saying that I've never spoken to anyone from either party and this isn't a part of a smear campaign, no one's paying me to talk about this, made this even more ridiculous. But I digress. So after I received the copy, I emailed Ezra again, following up with the initial request that I had made because she never emailed me back from the initial email that I sent her, like, hey, can I get a copy? They just sent me a new email with a copy of the subpoena. So they just were never responding to my emails at all. And she never called me back. I never got a response ever. So like I said, I followed up on the email that I sent on July 11th. I never received a response. So then on July 22nd, that's when I filed my motion to quash.
Did that go the way you thought it was going to go? Nope.
Guess what happened next? 2 days later, Blake's team is reaching out to me. They emailed me requesting a call. So I was assuming that it was a phone call. Well, come to find out that's not what it was. And whenever I was updating everyone in real time with my posts, Cassidy reached out and said that actually Zoom will show your IP address, which is one of the things that they have in the subpoena request. Now, I don't know if that was their intention or not, but it seems suspicious. But you know what was also suspicious? They already knew that I was doing all of this pro se, on my own, completely. And you know what they did? They were literally going to do a Zoom meeting with me against four legal attorneys. Okay? The next day, I emailed them letting them know that I would prefer everything of our conversations be in writing, and if they have any questions, to feel free to ask, and then I listed out my questions. Again, never got a response. But then the next day, Blake withdrew the subpoena. She withdrew it. So then Judge Lyman said that my motion to quash was moot because she withdrew it. So that's why I wrote a letter asking for sanctions, saying that you can still do it because of the power vested in you. But I found out that that letter didn't count as a formal request. So that's why I ended up filing this formal sanction request in August. So this took hours and lots of reading through legal cases, trying to find out if they were even, I could even use it for this. It was a whole thing. So when you see these, no, I did not have help. I was just scouring through the internet, and then I didn't realize that the format wasn't the same on these, so I apologize. But this whole ABCDEF, I was trying to get to G for ABCDEFG, get the fuck away from me. It was my version of this.
ABCDEFG. I have to go.
My first argument is that the plaintiff's subpoena was improper and abusive. Don't need to explain that, we already know all about it. The second argument I made was the withdrawal does not cure the abuse. I mentioned how the docket is full of her, issuing subpoenas and then withdrawing them, and how this repetitive pattern basically shows that she did all of this in bad faith. Just throwing that out there. I also stated that the statements allude that what Blake said in one of their filings, that it alludes that I provided some kind of information to them or that we had some kind of conversation, and that never happened. Like, we did not talk. I told you what happened. I followed up, they never responded, and then the next day they withdrew it. But then they tried to make some statement acting like, oh, well, because we got the information we needed, we are now withdrawing it. What information did you get? I stated, it reiterates that plaintiff had issued the subpoena for malicious intent to chill movement's First Amendment rights. ABA model rules of professional conduct. Yes, I went after Ezra. I'm looking at all of you in that legal firm. A lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third party, or use methods of obtaining evidence that violate the legal rights of such a person. Does that sound familiar? Then I also made reference to plaintiff used the subpoena to embarrass, discredit, and burden me. And now public supporters of Blake are using this as, look, this is proof that she was a part of a smear campaign. No.
Welcome to Misinformation 101.
12 seconds later.
Those content creators weren't in any trouble. They weren't being silenced. Their content wasn't being questioned. Their content wasn't being collected, except for a few on TikTok. I believe there was...
Oh, yeah.
My final argument was sanctions are necessary to deter repetition. We need someone to tell Blake to stop, please. And if you don't want your court to be ran like a circus, stop acting like the ringmaster, okay? So I said that while the motion to quash may be moot due to withdrawal, the court retains full authority to issue sanctions based on conduct that has already occurred. And then I, gave some examples, and they confirmed that the court can utilize its inherent power for bad faith conduct in litigation. Letting him know, you have all the power, my dude. Please use it. Inherent powers are governed not by the rule or statute, but by the control necessarily vested in the court to manage their own affairs, so to achieve an orderly, expeditious disposition of the cases. Please, Lyman, give us a break.
Do you think that could happen?
I concluded asking Judge Lyman to impose the most severe sanctions to the maximum extent. So we'll see if that happens. We got a 50-50 shot here. It went unopposed because while everyone was worried about Taylor being deposed, I just slid under the radar and I didn't say a thing on purpose. I purposely did not mention anything about the docket or what was going on at the time, just to continue staying under the radar long enough for it to go unopposed. Because once it hit that time frame, it officially is unopposed. So then that's why it's in judicial review now. So I am so excited to see what happens. Any day now we can get a response. Yeah, like I said, I'm not holding my breath, but I'm trying to stay positive because either way, even if he doesn't go for it, this will help Justin's case when it comes to him appealing, because why didn't he sanction Blake for all of this? Come on. A few ways this may play out. The judge might order a reprimanding of the party saying like, hey, this crossed the line. And it also damages the parties or the lawyer's credibility before the court. He may also order restrictions on future conduct, so they may have to get permission anytime they want any requests from here on out. This one isn't too huge just because discovery is almost over. This last one is rare, but still on the table. There's always a possibility. A dismissal related or evidentiary sanctions. So there's a possibility we could get this whole smear campaign thrown out. I'm just saying, I hope this is what nails it. Get that out of here. There's not a smear campaign. So next, what's your next argument? What's your next argument, Blake? Did he do it or did he not? Just asking. And then there's also a referral disciplinary action where the judge will actually go to the bar and let them know like, hey, we're filing a complaint with these lawyers because of how they conducted themselves. Again, we'll see. What do you guys think though? As always, this is all alleged based on my experience, so take it with a grain of salt. And as always, follow me for more.